speaker against. That still does not, as my lord said, deny me the primary membership of the political party. I'm still entitled to approach the election commission for whatever grievances I may have.
That you have said, so that you are not removed as a member of
Yes.
the party. You may be removed, correct, disqualified as a member of the legislative party.
And now, my lords, they sought to rely on Sadiq Ali to say that, look, both the words legislative and organizational majority have been referred to in Sadiq Ali. Now, organizational and legislative majority is referred to in Sadiq Ali from the perspective of the EC deciding, not from the perspective of the speaker embarking on an inquiry as to who represents a majority in the political party. Then they relied, my lords, on to say that this will have a bearing on the matter because a judgment of this court said, and I'll read out in what context the judgment was when I come to the case law, to say that any disqualification ex post facto relates back to the date when you were disqualified. And thus, if they were disqualified on that date, that's the end of the matter. Quite apart from the fact that even if I was disqualified, it doesn't stop me from going to the EC. But the reason the Supreme Court said ex post facto, and there are other paras that I need to show, was this. That was a case of a BSP government in Uttar Pradesh. A decision was taken to dissolve the assembly. The cabinet decision was yet to be communicated. I'm just very briefly giving. 13 MLAs of the BSP went to the Samajwadi Party and said, stake a claim to form the government. Because these 13 MLAs went to the Samajwadi side to stake a government, Mr. Maurya at that stage made a petition to the speaker saying that this is an overt act on part of 13 MLAs to show that they have voluntarily given up the membership of the party and thus they ought to be disqualified. So the speaker was seized of this issue of disqualification of MLAs as on that date because 13 MLAs had gone to the Samajwadi Party side. In the meantime, another 24 MLAs joined the 13 MLAs and they claimed that there has been a split in the party. Now the speaker went ahead and decided the issue of a legitimate slip with 24 joining 13 and did not decide the issue of disqualification, which Mr. Maurya prior in time had directed, saying that your very act of going and seeking support from the Samajwadi Party amounts to giving up an anti-party activity, voluntarily giving up membership. In that context, the Supreme Court said, as far as exercise of powers by the speaker is concerned, this disqualification will relate back to the date when the speaker was required to exercise the jurisdiction and the speaker could not have decided on the split within a party without deciding their original disqualification from the House, which stood there. It is in that context that the word ex post facto was used. And I'll show those two specific paras. The same judgment, my lords, the Supreme Court then goes on to say that you as the speaker can't embark upon and decide within a political party what happens. Your lens is only the lens of a legislature party that you have to see it. And inherently, my lord, the proposition which is sought to be forwarded will be impossible to implement. A, the Constitution doesn't say so. B, practically and inherently, it's impossible if you expect the speaker to get into these issues of lakhs and lakhs of memberships across the country without the necessary adjudicatory machinery.
So according to you, both the powers are different. Jurisdiction under both the powers are different. Correct, and the inquiry under both are different.
Completely different. If at all, my lords, if at all, a finding of the EC may help speaker, if at all, but nothing that the speaker decides will ever impact a member approaching the election commission. So to say that the two petitions are intertwined, thus this must await the decision in the main matter, is completely wrong. Now, my lords, even as far as that one question which is referred to, which is the last question, J, which I just
scope of powers of the EC. With respect
My lords,
to
all
determination.
that is, I'm very clear. What is the scope of powers of the Election Commission of India with respect to determination of split within a party? No one has questioned. The vires of the symbols order has already been upheld by your lordships. No one has ever questioned the power of the Election Commission. All that has been said herein is the scope of the powers of the Election Commission. Now, if I were to accept the argument as sought to be forwarded by the petitioners, my lords, then till the Constitution bench of this court decides on the scope of powers of the Election Commission. This may be the Shinde versus Thackeray matter, but there could be another matter where there are disqualifications of MLAs and another set of people go to the Election Commission. So the Election Commission is denuded of its powers as a coordinate constitutional authority to continue and do what it is mandated under the Constitution to do, because your lordships are seized of the question of the scope of the Election Commission. This is one matter, my lords. All that has been said, court in its wisdom thought that the scope of the powers needs to be looked into. My respectful submission would be, my lords, even the scope of the powers divorce the symbols order in the light of judgment of your lordships is expansive and plenary. But the symbols order itself under clause 15 and 18 specifically provides for a situation like ours, which is rival factions within a party, interim directions to be given. And my lords, your lordships in any number of judgments again have held that pendency of disputes does not bar the Election Commission from issuing any interim direction which it feels is necessary in the interest of justice in the meantime. Now, another argument raised was, what happens if the Election Commission suddenly freezes the symbol? Who will be able to contest? There'll be mayhem, there'll be chaos. What will happen? Now, my lords, your lordships have also held that you are entitled, if you represent the overwhelming majority, whatever you think you represent the overwhelming majority within the party, to go and say that we are entitled to represent the party and use the symbol. That's your legal right. Symbol is otherwise not the property of an MLA. It's the decision of the Election Commission. But I have a legal right to claim that I can use it. That's one that I can do in this matter. Presuming, suppose a situation were to arise in the court and the Election Commission was to come to a conclusion, no, we can't decide. There are orders, there are freezing orders that have been passed by Election Commission, and in the intervening period, temporary symbols have been given. Those are not jurisdictions of Election Commission to decide. You today in a 32 want the court to be seized of the matter, exercise the jurisdiction of the speaker as a court of first instance, exercise the powers of an Election Commission under a 32, and none of these constitutional bodies should be.
Yes, Mr.
My lords, I have two judgments to show to one.
Which are those judgments?
One is, my lords, the Rana judgment. Other is Sadiq Ali. And third is Pananis.
Right, so we give you about 5 minutes after lunch.
Yes. My lords, just.
Yes. On the days, my Lord the Chief Justice indicated on the days when the Constitution bench sits, the Constitution bench runs for the whole day. So we continue.
We'll continue.
Yes. Unless I just require 15 minutes from your lord, because I need to show 3 judgments and some provisions. Indulgence, a brief supplement by me and Mr. Singh. 10 minutes each.
Right after Mr.
Paul finishes.
After Mr. Paul finishes,
Yes, sir.
maybe 5 or 10 minutes,
10 minutes
between the two of you,
by
and
the
then
clock.
we want to hear Mr. Datare
Yes,
because
yes.
he's preparing for a constitution body.
Most important.
Question number F.
Yes,
Or the referred questions. Question number F is what is the scope of the election commission?
that's
J.
J. We'd like to hear Mr. Datare. We do, of course, since we are appearing for party, we're here on this side as well, but we want to hear Mr. Datare.
Yes, my lords, I'll finish with it.
Now let's see at what point in time does paragraph 15 operate? On the date when he files this application, it is 19th of July. Correct, Mother? Can't be before that. Even if the election commission were to decide, it could only decide on 19th of July when he moves the election commission. But as far as disqualification is concerned, it relates back to the date when he acted under the 10th schedule, contrary to either the whip or having given up membership of the party. So his status to move on the 19th of July will depend on your lordship's decision whether he stands disqualified or not, and he's voluntarily given up membership of the party. Voluntarily given up membership of the party, which is the decision of a constitutional authority, then how do we move the election commission? And the election commission has no jurisdiction to decide whether he is a member or not. Para 15 will operate when both sides agree that they are members of the party. It has to be that way. Because he's claiming that I belong to a rival faction within the party. And he's claiming majority within the party. So where is the question, Malaks, of paragraph 15 operating at all in this case? Therefore, Malaks, to say that paragraph 15 is operative and is independent of all this, Malaks, with the greatest respect, Malaks, is contrary to the very scheme of the 10th schedule and the scheme of paragraph 15. Because paragraph 15 proceeds on the basis that you belong to the same political party and sections of a political party. If I have thrown you out, supposing I have thrown a person out, he can't move. He's voluntarily given up membership of the party. He can't move. And that's the decision of a constitutional authority. The election commission of India will decide much later. The question
Yes. Mr. Zibal, what's the next point now? We've got this part of this limb of your arguments here.
Yeah, so therefore, this is one part of it. Therefore, paragraph 15 doesn't come into play at all.
Right.
Now, let's look at it on basic principles. We are here because there's a prima facie case. Surely, matter is pending. It is referred to a constitutional bench. Surely, the strong prima facie case, otherwise, he'd not be sitting here. 2, what's the balance of convenience today? That so far the election commission has not proceeded and the matter is listed for hearing. And there is nothing that's happening. No election that's happening. In the Bombay High Court, there is a stay of the BMC election. Yes. Supreme Court.
Now, the stay on the elections to the BMC has come about as a result of which order?
Supreme Court.
The court, this court's order.
Supreme Court.
Not the Bombay High Court.
No, there is no stay at all. There is no stay of PMC elections.
In one of the submissions I read yesterday, that they have said that there was a stay for a period of 5 weeks. That's what they have said.
If they produce the order, there is no stay. The best of us knowledge. Hold on. There is no stay today.
The matter is coming up tomorrow in the High Court, and the state and Maharashtra Supreme before court number 2. State is asking for time of 2 weeks.
In the Bombay High Court.
Yeah.
Oh, yeah.
Yes.
That order is passed on 22nd August 22 in SLP number 19756 of 21. I can't understand why there's a chorus of
Dr. Singhvi, SLP?
SLP 19756 of 21 by your lordship's 22nd August 22, titled Rahul Ramesh Wagh versus State of Maharashtra.
And they have asked for 2 weeks' time.
But I beg your pardon, Manoj, that's the OBC reservation matter, nothing to do with the, my learned friends are thoroughly good.
It's totally wrong, Manoj. PMC elections, the state came out with an amendment that was specifically challenged by us for directed status for my learned friend is not appearing in that matter, so he doesn't.
No, I'm talking about the matter that's coming up in the High Court tomorrow.
As far as PMC elections are concerned, there is a status quo, Manoj. That order we have placed, Manoj, in our written submission.
All right.
I'm just saying, Manoj,
That's for the balance of convenience. Sure.
But the matter tomorrow is about the OBC.
We'll hear you, Mr. Yadnani, we'll hear you. Let's follow some order. Yes. All right.
lot of enthusiasm moreover. That's all right. Normally, the point is, what's the balance of convenience? So far, it has continued. Matter is going to be decided by your lordships, Manoj, and it will determine, all the issues will be determined.
All right. So prima facie case and balance of convenience.
And then, Manoj, irreparable injury.
Yes.
Do not decide this matter and allow the election commission to go on, and the election commission freezes the symbol. What's going to happen? It's irreparable injury. Was to be. Without determining the issues that are pending before this court. And if those issues are decided in my favor, and you allow the election commission to proceed, see the consequences of that.
Yes, Mr. Sibal, we've made a note of that. So anything else, Mr. Sibal?
Don't take time without repetition. Very brief.
Who are you appearing for, Dr. Singhvi?
Because there are 8 petitions I am appearing for the
All right.
Tamil
Yes.
parties, because we are on this side versus that side.
And you will be characteristically brief, Mr. Dr.
I am
Singhvi.
grateful for the word characteristic. Correct. Your Lordship has always rendered me speechless before I started. May I be very pointed. Well, your Lordships has 4 points in the 10th schedule. The issue is narrow. Whether your Lordships on a
Can you just formulate the 4
Yes.
points?
Before I let me do that. Today, your Lordship is not hearing the matter.
Right.
Today, your Lordship is deciding the correct balance of convenience to endure till such time after Diwali, your Lordship hears the matter and renders judgment. That's the only issue today. Now, whereas for that, far from being unrelated, as the other side is saying, the issue is in direct collision and inextricably intertwined. That's the first point. I will demonstrate that in a minute.
Just a moment.
Direct collision and inextricably intertwined.
Yes, Dr.
Number 2, it is for that reason, and I'm not saying it's a judicial order, but it is for that reason that your Lordships has advisedly, in different combinations, from 4th of August 22, made it clear that people will seek adjournment in the Election Commission and the matter will not go on. There have been 3 dates in between, from then to now, including one coming up later this week or next week. So it has been adjourned. That was the Lordship understanding. Of course, subject to the Lordship adjudication today, no doubt.
Tilda's application was heard.
Number 3, why this inextricable intertwining and collision, Willis? There are 4 elements of the 10th schedule, which Mr. Simple has shown, but those need to be summarized. Willis, one is the phrase original political party.
Just a moment.
This phrase is very important. Political party, oblique original political party. Now, Willis, I stopped at clause 4 of the 10th schedule. Till clause 4, if my counting is not wrong, this political party, original political party, has been used 8 times. 8 times. But there are many more. I'm just giving Lordship
Original.
original political party, and sometimes they say political party in the same context. If your Lordship sees 1C without reading it, it's been read to your Lordship, but just keep it open with us. Then 21A, and these are hard, these are the operative provisions. then explanation. So 1C, 21A, then explanation A. I'm sorry, my apology, was 21B also. 21B also. 21A and 21B. Then explanation A, explanation B, I, double I, actually much more than 8 actually. You should look at the sub clauses. Then 2 bracket 2, then 4 bracket I, and many times in clause 4. Now, Willis,
Interestingly, Dr. Singhvi, where does the expression original political party in 1C appear in the text of the 10th schedule?
yes, yes,
Just as a matter of curiosity, I mean,
yes.
nothing really would turn on this.
Willis, when they say
It's in 4. It's in 4. 4.
in
4.
4 in the merger,
Where is original political party merges with another?
because the political party phrase in the other clauses means the same thing. I'll tell you in a minute why. Because the idea in a minute I'll come to it. It's the same concept. Now, Willis, this is directly would be an issue on a subsequent date before the election commission, even on their reading of the symbols order. I'm not accepting the application, etc. All that is separate. On their reading, the symbols order clause.
Dr. Singhvi, can you just formulate the 4 elements and then you can
Yeah, I'm
briefly
sorry.
argue?
Yes. So
Because
the
this
first
help
element-
us in.
Yes. Number 2, of the 4 elements, the first is political party, the second, split group faction all out permanently from 2003 WEF 1104. Permanently out. That was the big bullets pain because you created an anti-defection law. It was circumvented so easily. Therefore, and we have not yet heard, Your Lordship, not hearing the matter. If Your Lordship reads the statement of objects, it's very graphic to prevent precisely what is happening now. So, element number 2 of the 10th schedule, no form of split group or faction. Because that is directly what the election commission has to do.
Right.
Directly. In a minute, I'll show you. Number 3,
Directly?
that is exactly what the election commission is asked to do in the symbols order. I'm just saying, Willis, it is suggested that Your Lordship is unrelated to issues. Hear this matter in November. Let the election commission go on. Because how unreal would that be? Kindly consider. How duplicative. How irreversible. Number 3. And the statement of objects when we come to the final hearing will show that. There is a necessary condition and then there is a sufficient condition in 10th schedule. It's a cumulative combination. Now it is common ground, I repeat, that the necessary condition may have happened, but the sufficient condition not alleged to have happened. What is the sufficient condition for this? You have to, inverted commas, not recognize, break away. And then, because now that there is no split, so more than 2/3 go. That means it's the new group. That group by itself makes no difference to the 10th schedule. Suppose, let me give an extreme case. Out of 100, 90 go. Or 75 go. Unless the second sufficient condition is cumulatively satisfied, that is irrelevant. That is the whole purpose of the amendment. They have to merge or declare by merger, create a new political party. But only merger is the sole defense. Just bear with me on clause 4 for a minute. Just this needs to be read. Clause 4. That was the whole idea of substituting merger for split. It is nobody's case that in whatever form Shiva Sena exists there, in our whatever factions, that it has merged with the BJP. Now, a member of a house shall not be disqualified under 2(1). That's the only defense. It's an exemption. You will not be disqualified if this happens. It's like an exemption. a member of a house shall not be disqualified under 2(1), where his original political party, the question Justice Chandrachud asked, merges with another political party, and he claims that he and any other members of his original political party have become members of such other political party, or as the case may be, of a new political party formed after such merger, or have not accepted the merger and opted to function as a separate group. This will be for the balance 25 or 10 in my example. Because you've gone 75 are gone, 10 are left, 25 are left. And
So the people who remain after a merger,
That's right.
their entitlement to be legislators is not taken away.
Because
You are entitled to say, I don't form a part of the merger. I stay back and I continue with my own.
I'm very grateful, Manas. I'm very grateful. Because Manas, and quite right, it is not their fault. The remaining 10 can't be disqualified because 75 have gone with it. So that's a very logical. Now just continue the suffix. Suffix is important. And from the time of such merger, continues, such other political party or new political party or group as the case may be shall be deemed to be the political party to which he belongs for the purposes of sojourn. Now,
Deeming occurs subsequent. The deeming doesn't occur prior to Raj.
that's one of the important points of time. Absolutely right. So, Malas, merger is the only difference.
Yes.
Now, and may I state the fourth one and then I'll make my submission. The fourth element is the election commission in some form will be deciding a majority. I'm using the word largely and loosely. Majority. Now, my question to myself is, how does the election commission maintain a complaint by people who are not recognized under the defection law as a merged party? Number one.
Just a moment.
How do they enter the door of the election commission? Look at the irony here. This is very interesting political irony here, which I'll come to in a minute. You can't maintain my complaint because you asked me at the door, who are you? How have you come here? Second, the election commission will decide majority by persons who, if they proceed, you will be disqualified tomorrow. Well, can your lordship form any part of a majority if somebody is disqualified? But deciding this bunch of people is disqualified or not. They will be the same people who will be the majority considered by the EC and will be subsequently held to be disqualified. Well, it is putting the cart before the horse. I don't understand why a constitution bench can't decide the basic issue and the election commission can wait. What is the value? What is the urgency? What is the value of convenience? It is to make it irreversible. It is to make it a fait accompli. It is to then come and say, oh, there is the constitutional authority which has decided. Now what is left? That is the real purpose.
All right. Yes, you got your 4 points. Mr.
Now,
Foxy, go to the next point.
You just note for one thing. Well, if you are, what happens, brothers? There is a dilemma which is there. You have left the Shiv Sena, but you want to have the goodwill of the Shiv Sena. So you don't merge. And you merge and knock at the doors, you'll be a new political party, subject to numbers. You want the best of both the worlds. You are admittedly claiming that you are the Shiv Sena, which is a concept not recognized in the 10th schedule. Where is it recognized? Anywhere. And you want to yet call us a Shiv Sena and yet say that no, you can go. Well, in what form? This is driving the coach and four through this. And Wallace's fifth point is, this thing was enacted, Wallace, 15 years, 20 years after, on the Ayaram scourge, with a huge amount of discussion, and amended in 2003. We are talking of largely a procedural construct of a symbols order, how the election commission will proceed.
Dr. Singhvi, you're right. Dr. Singhvi, you're right that the 10th schedule does not recognize who is the real who is the real party? Party A, you are the Shiv Sena.
Yes.
But is that a concept which is alien to the symbols order? No.
Well, it's-
The symbols order, who represents or who is the real party
Yes.
is not alien to the symbols order. You're right, because the 10th schedule is extremely tightly structured. The only defense is that of a merger. There is now no defense of a faction, of a split, of a one-third split. Yes.
Two answers. One answer is that assuming it is so, I'm not conceding that, I'm just answering a lot of two alternative points. That has to logically follow, not precede. It's the
See, let
first
me tell you what is really troubling is this.
Yes, yes.
The whole concept of disqualification is in relation to the House.
Yes.
All right. The jurisdiction of the Election Commission is to decide who represents the political party, right? Which of various factions represent the political party. The Election Commission exercises superintendence and control over the elections under 324, Article 324. What happens on the floor of the House is a microcosm of the consequence of the holding of an election.
Two or three answers. I appreciate
Right? That, so that is an area where, there is a little bit of constitutional thought to be done.
Answer number one. The Election Commission has to look at the legislative and the non-legislative wings of the party, decided by your lordships repeatedly, including the famous case of Sarojini. That's answer number one. Your lordship should not be under the impression.
So your contention is that therefore, because your contention really is that because the legislative wing of the party
Yes.
is brought under a cloud by virtue of the disqualification proceedings, therefore the Election Commission is necessarily then to be stultified or to be interdicted from exercising its jurisdiction in regard to the non-legislative part of the party. That's an area which is a little bit of
That is Sadiq Ali. Well, I were to appear in the Election Commission symbol of the cases. What they
Now compiling.
give your.
I just give one.
Three or four answers. Just kindly take this common convenience compilation. This will solve a lot of problems. There is this volume I have taken out of this. Your lordships had them taken out. It's called common convenience volume. Just 2 or 3 pages.
The
there
old one.
Old one.
Double one.
Common convenience volume. Old one.
क्या मेन पेपर बुक में है